comprehensive look at small business contracting reform. We held numerous hearings and held roundtables, eventually settling on a package of common sense contracting reforms. These reforms were passed by the Small Business Committee in early 2012, adopted as part of the National Defense Authorization Act in 2013, and eventually signed by the President January 2nd, 2013. Unfortunately, what should have been a bipartisan success story has soured due to inaction and inattention. A year and a half later, the vast majority of these reforms remain unimplemented, and this is causing real harm to small businesses. We are a society of laws, and all businesses need to know what laws apply to them so they can comply and so they can thoughtfully chart their future course. For example, Congress began reforming the mentor-protege programs with the 2010 Small Business Jobs Act and then continued this in the 2013 NDAA. However, no proposed regulation or program guidance has been forthcoming from the Small Business Administration on this topic. This means small businesses don't know if they should pursue a mentor-protege agreement at the Department of Homeland Security or if the SBA will declare the program invalid in a year. This creates an unnecessary barrier to growth. Likewise, Congress has enacted numerous reforms to make it easier for small businesses to team, as these also have not been implemented. Not only do they harm small businesses with teaming, they also face contradictory regulations, statutes, and contract provisions. Small businesses are not set up to be arbitrators of the law. We need agencies to implement regulation in a timely fashion. While I understand that some rulemaking issues may be complicated, that does not excuse a failure to meet statutory deadlines. Furthermore, I fail to understand why it took the SBA 19 months to simply publish the name of their suspension and disbarment officer online. This requirement required no regulation and could have been done so in a matter of minutes. But the SBA didn't post it until this morning, 569 days after the President signed this bill into law. Further, while the information may be technically on the website, it is exceedingly difficult to find. Typing suspension and disbarment into the search tool does not actually take you to the suspension and debarment officer or office. There you go, Em. Thanks. This delay is a perfect example of how bureaucratic barriers to private sector growth work. SBA has been busy by spending $39 million on SBA-created initiatives rather than implementing the law passed by Congress and signed by the President. Today, our first panel will help us understand what the lack of implementation means to small businesses in a practical sense. Then the SBA will join us for a second panel to explain to the committee what steps are being taken to implement these needed reforms. I want to thank the witnesses again for being here. I now yield to Ranking Member Meng for her opening statement.
Thank you, Mr. Chairman. I appreciate you holding this hearing on this critical topic. The Small Business Committee and this subcommittee in particular have a long tradition of working in a bipartisan manner on procurement and contracting issues. Together, we've worked to modernize the SBA's contracting initiatives while exposing fraud, waste, and abuse in a range of small business procurement programs. It is my hope that today's hearing will continue in that direction. By examining changes to small business contracting policy included in last year's Defense Authorization Act, we can hope to further improve this process for our nation's entrepreneurs. For small businesses, federal agencies can be a great client. Last year, the federal government spent $461 billion purchasing a wide range of goods and services. Federal agencies require everything from paper clips to airplanes to landscaping to construction, and small companies are vital to meeting these needs. Congress has long recognized the many benefits stemming from small business participation in the federal marketplace. Helping small firms land these opportunities spurs job creation and helps small companies grow into larger ones. Often, when a larger company is awarded a federal project, its existing workforce can absorb the new demand for its products or services. However, when small companies take on government work, they often must increase their capacity, growing their payroll and creating new jobs. This, in turn, generates greater overall economic opportunity in communities where small businesses are located. The public also benefits from this arrangement. Small firms provide excellent service and quality products at competitive prices. When the government does business with them, taxpayer dollars are well spent. Moreover, bringing additional small companies into the procurement pool creates competition, thereby driving down prices and boosting service quality. Given the valuable public benefits of having government do business with small enterprises, it is important that federal agencies be proactive in this area and that small firms be able to navigate the procurement process. Unfortunately, this has not happened. The 23% small business contracting goal has not been met in many years, although it appears that objective may finally be met this year. Still, those numbers are not final. Even if, at long last, the federal government has finally met its 23% goal, that alone is not sufficient. The 23% goal should be considered a floor, not a ceiling, when it comes to small business participation. Similar initiatives aimed at helping women-owned businesses have fallen short. The service-disabled veteran-owned small business program has also not kept pace. In that regard, it is worth discussing whether raising these goals would be a useful step. However, if they remain simply that, unenforceable goals, and there is no penalty for failure to meet them, it is unclear how changing the numbers will actually get more disadvantaged small firms involved in the procurement market. Part of the issue has been a failure to invest the appropriate resources to ensure small firm participation. An overworked staff of procurement center representatives is tasked with expanding outreach to the small business community. However, with their ranks thinned, the fact is that they simply do not have that manpower to police every procurement action and ensure small businesses get a fair shake. Of course, our committee is familiar with how big companies have historically gamed the system, siphoning off projects that should be designated for small firms. Whether it is hub zones, the Service-Disabled Veterans Program, misuse of pass-through arrangements, or simply miscoding big companies as small ones, we all know that there are significant problems in the procurement process. In sum, Mr. Chairman, there is no shortage of policy obstacles that prevent small firms from winning their fair share of federal contracts. It is my hope that today's discussion will take a broad look at how we can rectify some of these problems while working to improve the process for entrepreneurs. Whether it is the legislation passed by the committee earlier this year, changes made through the Defense Authorization Act, or simply enhanced oversight, we must continue pushing to ensure small businesses are not locked out of the contracting process. Thank you to our witnesses for being here today, and I thank the chairman again and yield back.
Thank you. I'll just quickly explain the lighting system. It's 5 minutes. When it gets yellow, you have another minute. Try to stay close. We want to hear what you have to say, so we'll be flexible. For our first panel, I'm pleased to welcome Angela Stiles. Ms. Stiles is a partner with Crowell and Mooring, specializing in federal contract law, and proved herself a great friend to small businesses when she served as the administrator for the federal procurement policy. Next to her is Larry Allen. Mr. Allen, president of Allen Federal Businesses Partners, a small business in McLean, Virginia, that helps small and large businesses navigate the federal procurement landscape. Our third witness is Ms. Charlotte Baker, the co-founder of Digital Hands. Digital Hands is a woman-owned business, a small business specializing in managed security services. She is here today testifying on behalf of Women Impacting Public Policy. Our fourth witness and final witness on this panel is Dr. Damian Specht. Mr. Specht co-founded Jenner and Block's Government Contracts Corporation Corporate Transactions Group. Again, welcome you. Ms. Stiles, you may begin.
Thank you very much, Chairman Hanna, Congresswoman Ming. I appreciate the opportunity to appear before you today to discuss the impact of the Small Business Administration's failure to implement federal contracting reforms mandated in the National Defense Authorization Act for FY 2013. SBA's failure to act has created significant ambiguity for federal contractors, both small and large. While this uncertainty keeps the lawyers, like me, busy, it costs contractors and results in higher prices for the federal government. As chair of Crowell & Mooring's Government Contracts Group and the former administrator of the Office of Federal Procurement Policy, I work with contractors affected by SBA's inaction every single day. We have started to see a dramatic increase in compliance questions related to these unimplemented provisions. But there's one specific provision, and a complicated one, that I want to focus on today. The 2013 NDAA modified the Small Business Act to change the limitations on subcontracting for federal prime contracts awarded to small businesses under set-aside programs. So, for example, when a federal procurement is set aside for competition among small businesses, the winning small business prime contractor is restricted from subcontracting more than a certain percentage of the amount paid by the federal government to another business. For service contracts, the NDAA provision provides that the small business prime contractor may not expend on subcontractors more than 50% of the amount paid to the small business prime contractor by the federal government. So, for example, if you receive a contract award for $100 as a small business, you can't subcontract more than $50 of the award to a large business. It's simple, it's easy to apply, and it's really easy for everyone, whether you're a prime contractor or you're a subcontractor or you're the government. The NDAA statutory provision was a meaningful change because for many years, and guess what, still existing in current unmodified form in SBA's regulations in the FAR, the limitation on subcontracting regulations require small business prime contractors awarded a prime contract on a set-aside basis to agree to something completely different, that at least 50% of the cost of contract performance incurred for personnel shall be expended for employees of the small business prime contractor. In practice, what constitutes the cost of contract performance for personnel has been absolutely impossible to understand or to implement. So, for example, if a small business prime contractor is awarded a $100,000 contract to maintain trucks at a military base, and the small business prime contractor wants to subcontract, say, engine maintenance to a large business, the small business prime contractor has to convert the $100,000 firm fixed price contract into a cost of performance metric under the current regulations that have not been modified to take into account the NDAA statute. It's really a cost reimbursement contract that they have to convert it to, and they have to compare the cost of their small business cost of performance for personnel to the cost of performance of the large business contractor. Nobody knows what they're doing. Nobody knows how to administer this correctly, and the uncertainty has led to many disputes with the government and between prime contractors and subcontractors. The NDAA changed this requirement into a simple calculation. In my example, the small business prime subcontractor, the small business prime contractor could subcontract $50,000 of the award to a large business. Simple and easy to administer and understand. The SBA's failure to implement new regulations consistent with the NDAA is creating chaos. A contract executed by a federal agency today with a small business contains the old regulation, which requires at least 50% of the cost of contract performance incurred for personnel is expended for employees of the small business prime contractor. The contract clause does not exempt the small business from also complying with the NDAA provision. So compliant and diligent small businesses are left in the position of implementing two inconsistent provisions, one that's in regulation and one that's in the statute. This inconsistency is adding millions of dollars to compliance costs for small businesses. SBA needs to immediately begin this rulemaking process to resolve the uncertainty and to improve the business climate. The Small Business Administration's mission is to aid, counsel, and assist and protect the interests of small businesses. SBA's failure to act is crippling the very small businesses it's supposed to protect and to assist. Congress enacted common sense reforms to clarify the complex limitations on subcontracting, allow small businesses to team more effectively, eliminate regulatory compliance burdens, and provide opportunity for new small businesses to get into the government contracting business. SBA's failure to act has denied these benefits to federal contractors, large and small, results in inefficiencies and lost opportunities for economic growth. This concludes my remarks, but I'm more than happy to answer questions.
Thank you. Ms. Baker?
Chair Hanna, Ranking Member Ming, and distinguished members of the subcommittee, thank you for the opportunity to testify this afternoon. My name is Charlotte Baker. I'm the CEO of Digital Hands, a Tampa-based IT company that provides innovative IT services to large enterprise companies as well as public entities, helping them in their ongoing war against growing cyber threats. I'm here today representing Women Impacting Public Policy, or WIP, as a member of their Education Foundation Board. WIP is a national, nonpartisan public policy organization advocating on behalf of its coalition of 4.7 million businesswomen, including 75 business organizations. My testimony will focus on the urgently needed rulemaking that will enable my business, as well as many other small businesses, to win more federal contracts. Specifically, we need the SBA to implement Section 1651 of the FY13 NDAA as soon as possible. Previously, WIP testified on the importance of changing the law with respect to contracting, and this committee oversaw its passage. So let me take this opportunity to say thank you. I'd also like to take a minute to explain the subcontracting changes contained in Section 1651. The section makes an important change, that the 50% prime contractor work requirement on set-aside contracts are made on the basis of total contract dollars rather than based on the current method of labor cost. This change ensures that the majority of dollars set aside for small business goes to that small business. Equally important in Section 1651 is subsection B, which allows similarly situated entities to contract with each other without specifying a percentage of the work that each is required to do. Previously, the law limited subcontracting to 50% of the labor cost on set-aside contracts. For purposes of definition, a similarly situated entity is a WOSB prime contractor winning a WOSB set-aside and subcontracting work to another WOSB firm. Another example is a small business prime contractor winning a small business set-aside contract and subcontracting to another small business. So why is this important? Because it affects companies like mine that perform complex IT services. Let me give you an example. Several months ago, a significant IT requirement was posted by an agency. Digital Hands and another EDWOSB planned to team together to meet the scope of work. The other EDWOSB, the prime, was to provide logistical support and access to a federal supply schedule, while Digital Hands would have subcontracted to provide an innovative technology solution utilizing highly trained IT security personnel. In this case, Digital Hands subcontracting the work, the portion of the cost of labor provided by Digital Hands' higher paid security personnel would have resulted in a much higher percentage of cost than the 50% allowed to subcontractors. To further explain, while the majority of the hourly work, the number of hours, would have been provided by the prime through its lower cost technicians, the bulk of the labor costs would have come from us, from Digital Hands. Because of the current subcontracting rule, the 50% limit effectively prohibited us from bidding. On a broader level, promulgation of Section 1651 will ensure that dollars awarded remain with the companies who have the same set-aside designation and increased access to federal contracts for businesses like mine. As we continue to respond to federal opportunities, these elements are critical. My recommendation is simple. Urge the SBA to implement this provision as quickly as possible. Thanks to this committee's leadership, Congress passed the change. Now the SBA needs to implement it. The longer the delay, the more small businesses will miss out. Thank you for the opportunity to testify today. Hopefully my story will expedite the enforcement of this rule. I'm happy to answer any questions.
Thank you. Mr. Allen?
Good afternoon, Mr. Chairman, Ranking Member Meng, members of the subcommittee. I am honored to be here this afternoon to discuss the pace of the Small Business Administration's implementation of 3 sections of the FY13 NDAA. These laws limit the liability of companies receiving advice from federally supported entities, provide greater clarity about small business suspension and debarment procedures, and provide this body with additional reporting on that process. SBA delays in establishing rules for each of these elements are harming the small businesses that Congress wanted to protect. Section 1681 establishes safe harbor protections for small businesses that rely on advice given by either procurement technical assistance centers or small business development centers. Small businesses that take advice from these organizations believe that it is correct and has the support of an agency of the United States government. Without the implementation of this section, small contractors could find themselves in significant trouble if they act based on recommendations of an SBDC or PTAC that are inconsistent with procurement rules. There are many centers dispensing advice to many small firms. It is very possible that either incorrect or incomplete information could be dispensed. Without the protections in 1681, small firms that inadvertently fall into noncompliance could find themselves exposed to a host of problems. Under the Civil False Claims Act, for example, the government is entitled to triple the amount of monetary damages actually incurred, and in addition to an $11,000 per invoice fine. Once a small company is through with litigation, fines, attorney's fees, and other costs, it may find that its very viability has been compromised. The safe harbor provisions of Section 1681 would protect small firms from the worst penalties if their violations were caused due to reliance on faulty information provided by a PTAC or SBDC. Among the penalties at the government's disposal to discipline inappropriate contractor behavior are suspension and debarment. These penalties are commonly referred to as the death penalty in government contracting. A federal suspension or debarment brings all of a company's public sector work to a halt, even as a subcontractor. Suspensions and debarments are currently increasing. The GAO recently issued a report showing that such actions have more than doubled since 2009. Ironically, the same report identified improvements made in 6 government agencies to bring consistency and transparency to their suspension and debarment process, something the SBA is specifically supposed to do per Section 1682. The SBA was to issue new suspension and debarment regulations, new standard operating procedures, and identify a suspension and debarment officer, which they did, as you mentioned, Mr. Chairman, this morning. 2 things are happening without these rules. First, companies wrongly identifying themselves as small, an issue that this committee is familiar with, have an easier time fighting suspension or debarment proceedings. Second, truly small firms are suffering from the lack of a consistent, transparent process from the agency charged with protecting and promoting their federal market participation. Congress passed 1682 with the intent to protect small businesses. As a result of the SBA's inaction, though, small businesses may actually be treated more fairly at some of the other agencies. Section 1683 requires that the SBA issue an annual report to Congress on suspension and debarment. Since the SBA oversees many types of small firms, there are special precautions that must be taken. Congress is right in wanting to review agency actions here. While the initial intent may have been to suspend or debar companies improperly calling themselves small, this section can also protect real small firms from inconsistent processes. The specific report details called for in Section 1683 will give Congress a fuller understanding of what's happening. Publishing the information may actually result in fewer companies being penalized. Lastly, properly used, the information can also be used to help Congress make future decisions on appropriate small business legislation. We recommend that Congress continue to provide oversight on the SBA's lack of progress in implementing these three key elements of the 2013 NDAA and take steps to hold senior agency officials accountable for this inaction. I thank you for your time and attention and look forward to your questions.
Thank you. Mr. Specht?
Chairman Hanna, Ranking Member Meng, and members of the subcommittee, thank you for the invitation to appear today. Before I begin, let me state that my comments are my own, and I'm not speaking on behalf of my law firm or any specific client. My name is Damian Specht, and I'm a government contracts attorney with the law firm of Jenner & Block here in Washington, D.C. When the 2013 NDAA was enacted a year and a half ago, I discussed the legislation with both large and small clients. In general, they considered the NDAA to be a mixed bag for small government contractors, but reserved judgment until the legislation was implemented by the SBA. As we all know, little of that implementation has occurred. From my perspective, the most important change in the 2013 NDAA relates to SBA's Mentor Protege program. Many small contractors report difficulty convincing large prime contractors or government customers that they can successfully perform technically challenging or large-scale work. Large contractors also report difficulty finding the track record of success they need in a key small business subcontractor. SBA's Mentor Protege program fills this gap by partnering large mentors with early-stage 8A small businesses. The 2013 NDAA gave SBA the authority to expand the program beyond 8A firms, but I'm not aware of any public statement that SBA will exercise that authority. This has led to significant uncertainty in the contracting community as to whether expansion of this program will ever happen. SBA's delay may be the result of a number of difficult issues it must address. For example, does SBA have the resources it needs to administer a significantly larger program, or will application processing times increase and oversight be weakened? In addition, the NDAA states that the expanded program shall be identical to the Mentor Protege program for 8A concerns. But the current program is limited to companies in the earliest stages of the 8A process. As a result, SBA will have to determine if all small businesses should participate in the expanded program or whether participation should be limited to early-stage small businesses. From my perspective, the program was designed for early-stage businesses, so limiting proteges to firms that fall below half of their relevant size standard would be a good way to expand responsibly while focusing on businesses that will benefit the most. SBA can then revisit additional expansion in future years. The NDAA also required reform of agency-level mentor protege programs. In my experience, few clients are aware that these programs exist, and many confuse agency programs with the SBA's far more robust program. This can be a fatal error because only the SBA's mentor protege program offers an affiliation exemption for a large mentor and a small protege bidding as a joint venture. Because of this confusion, the 2013 NDAA's effort to increase uniformity among these programs was welcome. Now it is SBA's responsibility to resolve some key policy issues. First, will SBA impose a limit on the number of proteges a mentor can have or the number of contracts a mentor and protege can pursue? If so, will these limits apply across all mentor protege programs, or will the limits be applied for participants in each program? Given the difficulties of tracking all mentor and protege relationships, I would suggest that limits be imposed on an agency-by-agency basis. After all, ensuring every willing protege has a mentor for different aspects of its business can only be beneficial. Second, should the joint venture affiliation exception for the SBA program apply to other agency programs? Expanding the exception would limit confusion and encourage participation in all agency programs. Third, SBA must decide whether the benefits of different mentor protege programs should be uniform. For example, some agency programs offer small business subcontracting credit for costs spent assisting the protege. This encourages the mentor to follow through on its commitments, so I would argue that such efforts should be adopted across the government and added to SBA's program. As these issues highlight, we are at a key moment in the future of mentor protege programs. The goal of this effort should be expanding participation, but we cannot forget that expansion will require additional resources. Not all of the provisions of the 2013 NDAA are helpful for small businesses. As you know, the Small Business Jobs Act of 2010 imposed penalties up to the entire contract value on concerns that misrepresent their size. Although the 2013 NDAA added a safe harbor from this rule, The legislation and SBA's related rulemaking have a number of critical flaws. First, SBA has proposed allowing local development centers to choose whether to offer advisory opinions without offering additional funding. Given the additional work involved, what incentive do these centers have to issue opinions? Even if some offices choose to issue these opinions, what will this patchwork of resources mean for small businesses that are outside the region served by these offices? Second, SBA has not proposed a time limit for issuing these opinions. Size determinations can take months, and delays in advisory opinions cause small businesses to miss out on procurement opportunities. Third, SBA's proposed rule does not allow a contractor to appeal an adverse decision. Given that size determinations are regularly overturned by SBA's Office of Hearings and Appeals, small businesses require an appellate forum. In sum, it is essential that small government contractors and small businesses considering entering the federal space have the certainty of an effective safe harbor. Without significant revision, however, the currently proposed safe harbor is unlikely to meet that need. Thank you for your time, and I look forward to your questions.
Thank you very much. Amazing. I feel like we should be having a conversation with the SBA, which we'll have a moment. I want to thank you for being here and listening to this, too. That's a big help, I think, hopefully for you, too. Mr. Allen, how does the SBA's suspension and disbarment guidance compare with other agencies, such as the Air Force? And you mentioned that the remedy doesn't exist because you can't find the officer, and you can't define, then you can't define the rules, and that people can be basically disbarred or suspended without a way to seek a remedy. What does that look like compared to other places you may know about?
As I alluded to, Mr. Chairman, the GAO recently identified the Air Force, the Department of Veterans Affairs, and a couple of other agencies that had taken significant steps to improve the consistency and transparency of their own suspension and debarment processes, trying to make this a real business case for why you take that type of dramatic action. Without having these reforms, the SBA is really operating behind the curve, not using best practices. The result is that you can't be assured of consistent decisions. You can be assured that there will be, perhaps in some cases, a proper reason to appeal a suspension or debarment decision. But without that transparency and having best practices like those recommended by GAO, it may be difficult and costly for a truly small business.
Are you concerned that it's arbitrary and capricious by virtue of what you just explained?
Certainly more arbitrary and capricious than it is at other agencies.
So that really is dangerous when you have...
Yes, sir, particularly given the small business nature of the companies that are doing business with this agency.
Thank you. Ms. Stiles, you explained a few things you thought could be done pretty quickly. And yet some of these rules, I think 48 out of 52 requirements have not been dealt with, not been formulated. You want to talk about that? I mean, what are the ones that you think it's kind of ridiculous that haven't been done?
Well, I think the primary one that I talked
If
about.
that's true, I don't want to put words in your
No,
mouth.
I think it's absolutely true. I can't. It is unfathomable for me to understand how it's taking so long when it's really, many of these are minor regulatory changes that have to occur to create consistency in how contracting is happening. Even on the debarment one, you want small businesses to know where to go, to how to get there, what the process is for suspension and debarment, and not have to pay a lawyer.
Explain to anyone. Listen, you're an expert in this. This was your career.
Yes.
So it's not as if you're just an angry lady showing up here today.
I was in charge of the rules before.
You were in charge of the rules. So if you had that job, you'd have it done, or at least you'd have some done, right?
Absolutely. You know, it doesn't take that much to issue interim rules where a statute says the regulation has to change. It needs to happen. I mean, I can't tell you how much companies are having to spend to understand the differences and how much that's ultimately costing the government as well.
Do you think that's keeping the government from enjoying the best and most competitive opportunities?
Absolutely, absolutely. I think
That
small
was
businesses are
Emma's
confused
question.
and can't and don't have access that they need to have and don't understand the rules to contract.
Thank you. I'm going to yield to Ranking Member Meng.
Question to Mr. Allen. In efforts to increase small business subcontracting, commercial market representatives advise large prime contractors on maximizing subcontracting opportunities for small businesses and aid small businesses in marketing themselves to large businesses. In your opinion, are CMRs doing their job on this front? And how can they be more effective in increasing subcontracting opportunities?
I appreciate the question. My take is that you find a high degree of variability on the effectiveness of that type of advice from the SBA. It's really very highly dependent on the situation. A lot of times you will find that the lists of businesses that they reach out to and work with are fairly tight and confined to ones that they've perhaps worked with in the past, and their comfort level and ability to work with other businesses is not so good, so those companies don't get the help that they need. You're right in saying that large contractors take seriously their small business contract use. It's those efforts from the companies themselves that I think probably do the best job, whereas the SBA's resources are perhaps a little bit more scattershot in their effect. One of the best things I think that the SBA could do would be to be very active at a regional level with companies that can truly work with a larger prime contractor or even another small prime, because you find some very good people out around this country in those regions that can help the government, whether it's here or elsewhere.
Thank you. Question to Ms. Baker. The NDAA required SBA to provide a website for large businesses to post subcontracting opportunities. However, this has yet to occur, leaving businesses with looking only to the existing subnet platform. Have you found that this website has been helpful in providing these opportunities?
No, not whatsoever.
Do you think there are deeper problems or solutions that need to be rectified?
I think the dissemination of information through a mechanism that can be trusted and that is updated and readily available is important for all small businesses. Without this, what happens is the cost of customer acquisition or the cost of pursuing federal contracts is much higher, and it's done in an unorganized manner.
Thank you. And a question to Mr. Specht. The committee continues to hear from numerous small businesses about the problem of contract bundling. As a result of this practice, subcontracting and teaming have become the best options for small businesses that are unable to perform the entirety of these massive contracts. Yet, small businesses have faced difficulty in this arena as agencies may prefer a single offer rather than offers received from teams. What has your experience been when your clients have teamed up with other businesses?
It's a great question, and it's an issue that comes up quite a bit. Quite a bit of my practice is negotiating these teaming agreements between large prime contractors and subcontractors. And I can tell you that from the government's perspective, you need to be crystal clear with the evaluators as to who is performing what work. And the small, that may be a subcontractor, has to be extremely assertive about making sure that that's mentioned in the proposal. Because unfortunately, what often happens is that a small business will be part of a team, they'll negotiate a teaming agreement, and then after award, the small business will be cast aside, the large business will absorb that work, and the small business will have been used to get the award, but not to actually perform it.
And anyone else is welcome to answer if they...
That is exactly one of the fears of the small businesses going together with a prime contractor. What has happened to us in many cases is that we will put together the work. We will spend a lot of time putting together our side of it, and there is no assurance moving forward. You do have to be aggressive that you will be the chosen one, but there is no guarantee. With our peers, we have found stories that there have been promises made, and then in the end, the actual award that was bid on by the small business subcontractor was taken by the prime.
Thank you. I yield back.
Thank you. Mr. Tipton?
Thank you, Mr. Chairman. Thank you, panel, for being here. Just a couple of quick questions to follow up. Ms. Stiles, after the chairman's questions, in part of your answer, you'd said how much it's costing the government in terms of that. Can you expand on that a little bit? What is it costing the government?
So it's probably impossible to quantify, but I can tell you not an insignificant number of small businesses have come to my law firm to seek advice about how to comply with and the limitations on subcontracting rule in particular. If the rule was clear, if there was actually a rule in place implementing the NDAA, they wouldn't have to come, they wouldn't have to pay the bill. It adds to their cost, and at the end of the day, even if it's a fixed price contract, they have to pass the costs along somewhere. They will be passing those costs along in their contracts because they all have to figure out how to comply with two inconsistent rules right now. And it's been going on for, a year and a half, if not more. And they have to figure it out in order to perform the contracts. So they have to pay to get legal advice to understand what's the right thing to do.
Right. I'm a small business guy, and you like to be able to know the rules that you're playing under. Is this a chronic pattern that we're seeing? We had Mr. Allen speak that some of the other agencies are doing a little better job in some specific components, but is this a chronic problem that you're seeing?
I think so. I think that it's a chronic problem in terms of getting the rules out on time, understanding what the changes are, and just the sheer complexity of the rules themselves.
Well, that supplement, Ms. Baker, you'd just talked a little bit about the website, not truly being helpful in terms of dispersing the information in terms of the contracts. You're out of Tampa, Florida, if I recall correctly.
Yes, sir.
And your economy may be a little bit better than it is in my district in Colorado, a little bigger area. But do you have some people that could use some jobs down in Tampa, Florida?
Yes, sir.
If you had access to actually find out about these contracts, to be able to have some actual certainty in terms of going forward, what the rules are going to be, any kind of a guess on what type of jobs that might be able to create, what kind of security that might be able to create for existing jobs?
Yes, so the job creation for my sector of industry is not a low-paying help desk arena. And so having opportunities and having visibility to the opportunities that are in cyber creates jobs that are six-figure jobs. And these are newly created jobs. These are not allocating jobs from one area of the commercial segment, to the federal segment. It's actual new creation. So, what could it mean? The size of the contracts that are coming up, that are due, and the new opportunities for cyber threat detection really, create, in terms of compensatable jobs, millions. And we're talking, a job with one agency just on a cost basis could be a $2 million underlying cost structure.
Right. Great. And I like the chairman, and I know the ranking member as well. Appreciate the administration, Small Business Administration, for taking the time to be able to be here and listen to some of your comments. They're here. What would you like to be able to tell them? What can help? Ms. Baker?
My gist today, and the thing that I would love to urge, it's desperately needed, is that we invoke and we put into practice the similarly situated entities. Small businesses do not have the ability to go together when they're in the same class and compete without that 50% rule applying. In industries and in services and goods that are of higher value, it is impossible for somebody to come in and be a sub and meet that rule. As long as all the monies are going to the class of the similarly situated entities, I just urge that the good work that has already been done by this committee gets put into place so that we can move forward and not lose out on more opportunities.
Right. Yeah, Mr. Allen, what advice would you give in what you described as a death penalty when it comes to suspension and debarment?
I believe that the SBA needs to come up to speed on the suspension and debarment practices, follow the recommendations set forth by GAO. They are now easily identifiable as best practices as implemented by other federal agencies. That will let people know at least whether they are on one side of the fence or the other much more clearly. And for those that are on the wrong side of the fence, that will hopefully clarify the process and not waste resources. And for those that are on the right side of the fence, they'll know that and they'll be able to proceed accordingly.
Thank you. I yield back, Mr. Chairman.
Ms. Clark?
Thank you, Mr. Chairman, and thank you, Ranking Member Mang. I'd also like to thank our witnesses for your testimony today. My question is to Mr. Specht. Your written testimony goes to great lengths to discuss the Mentor-Protege program, a program I share enthusiasm for as well. Could you dig a bit deeper and flesh out your concerns regarding the possible opportunity costs should the SBA not exercise the NDAA's authority to further expand the program?
Absolutely. Yes, you're right. I'm enthusiastic about the Mentor-Protege program because I've seen it in action. I've seen large contractors work with smalls and help them build up the infrastructure and make them successful. But the concern is that right now, the only businesses that can be proteges are essentially early stage 8A participants, so small disadvantaged businesses in the early stages of their business career. And the problem is that many of those businesses are not yet sophisticated enough to really pursue the large contracts that interest a large business mentor. And so if SBA expands the program and we get more small businesses into the program, larger small businesses, somewhat more advanced small businesses, if we do that sooner rather than later, then more of these smalls will find more willing mentors who are willing to pursue these opportunities with them and willing to share their experience with the small business contractors.
Thank you. I saw a lot of heads nodding at the table over there as you were speaking. Would you like to add something, Mr. Allen, Ms. Baker, Ms. Stiles?
I would only add, Madam Ms. Clark, that I think he's absolutely right. Mr. Specht's absolutely right. In my experience, I've seen hundreds of small companies who are not ready to take that next step, even though they may initially think that they are. And those are the ones that can sometimes end up getting very easily frustrated, walking away from the market entirely. And the government misses out on some of the innovations that those companies can provide and are providing the commercial market. So staying with these businesses and giving them a real sense of understanding that this can be an 18 to 24-month process will, I think, encourage more of them to stay in, and we would all benefit from that.
In my experience and in talking to fellow WIP members, the Mentor-Protege program is something that's very attractive. It's very hard to come by, and one of the reasons will be that you don't meet a designation such as an 8A, or you don't have experience in the government market, even though you may have experience in the commercial market. And so there are a lot of barriers in the conversation about why you're qualified. And so it appears to me that we would benefit from opening up that dialogue about what the Mentor-Protege program is truly designed to do, and the fact that it is not a program for small businesses just to bring in their relationships. We have had conversations, a number of conversations that say, you know, prime contractor X, and this has happened, discussions with about 5 of them, would love to do a Mentor-Protege program, and the way that you get into the Mentor-Protege program is you bring them business. You bring them business, and then, you know, you've got to think about it, then who really needs who in this situation? So it's a source of frustration, and it's one in which my company has really would love to participate in, but I just don't see how it's worth the hassle and the time for us. We don't have an 8A designation. We are an EDWOSB, and it just seems that we have to take another route.
Mr. Chairman, I yield back.
Thank you. We're privileged today. Ranking Member Velazquez is here. Ma'am?
Thank you, Mr. Chairman. And let me take this opportunity to thank the witnesses for being here today. This is an area where I have devoted so much energy and time throughout the years as a member of this committee and advocating if there is a way where we could help small businesses do what you can do best, and that is creating jobs, is to have a level playing field for businesses to be able to access federal contracts. Ms. Baker, I would like to ask you a question. There are multiple advocates in place to ensure that small businesses receive a fair share of federal contracts and are not disproportionately affected by acquisition policies. Businesses have reached out to these advocates for guidance in navigating the insourcing process. Do you believe that these offices are doing enough at the front end of the decision-making process to ensure that small businesses receive fair treatment?
I truly believe that the intent is there, and I truly believe that shepherding small businesses to the right decision makers is something that the liaison officers have well embraced. The issue often that we have to overcome is, especially in my industry with cyber, is the thought process that the decision maker or the contracting officer does not believe that a small business can do the quality of work that we actually do and win awards for in the commercial sector. So, to deal with the small business liaison officer, to get to the right contracting officer or the actual buyer is something that is embraced by the advocate in the agencies, but they are not always effective in finding and reaching and being knowledgeable about the opportunities. And often when they are educated, it's to bring in a small business that really is a sub, when often we can actually be primes.
Okay, thank you. Mr. Allen, contracting officers are supposed to use market research to aid them in determining what contracts goes to what small business program. Do you really think that you found that contracting officers are doing the research prior to releasing solicitations?
In many cases, Ms. Velasquez, no. And some of that has to do with the fact that contracting officers have a lot on their plate. They're very overworked. That we've seen their number dwindle, particularly the ones that are experienced, relieving the government. The result is that you have a very uneven amount of experience in the acquisition workforce. So we don't always see that market research being done.
So I guess that you will agree with the fact that sometimes it might be, the rhetoric might sound good, that we can do more with less, but not in this case, where we have an agency that has one of the smallest budgets throughout the federal government, and yet we love to preach and talk about the important role that small businesses play. But if we don't provide the resources for the Small Business Administration to do their job, as well as the committee to do the work that we are supposed to do here, because I think that if we could come here and criticize SBA for not issuing the regulations, but then we have to understand what type of record, congressional record, there is that would allow for those who will be issuing those regulations to go back and see at the intent of Congress when we pass legislation here. It will be much easier for the SBA to have that wealth of information coming from the committee work. It is not right that we come and say and allow for other committee to introduce and put provisions in their authorization, defense authorization, when we didn't do the work here in the Small Business Committee. So it will be difficult for the SBA, and that creates confusion. And you touch on the debarment issue. Well, they need to go back and check what was the intent. But if we don't have a congressional record, they will not have that information, and that will make their job more difficult and more complex. With that, I yield back, Mr. Chairman.
I want to thank our first panel. I invite you to stay if you'd like. I know at least one of you has a plane to catch. We have votes at around 20 after, perhaps, so we should be able to hopefully work through this. Thank you again for your time and your willingness to participate at this hearing. I want to welcome SBA Associate Administrator John Shiraka. Mr. Shiraka is responsible for all the government contracting and business development programs at the SBA, including the insurance procurement regulations. Mr. Shiraka has appeared before this subcommittee many times, and I'm happy that he's here, and I'm glad you brought reinforcements. So, welcome.
Chairman Hanna, Ranking Members Meng and Velasquez, and members of the subcommittee. I am honored to be here today to present SBA's ongoing efforts to expand access to federal contracting opportunities for America's 28 million small businesses. SBA's Office of Government Contracting and Business Development oversees the federal government's performance against the statutorily mandated small business prime contracting goal of 23%. This includes ensuring that agencies meet the socioeconomic goals of 5% for socially disadvantaged small businesses and women-owned small businesses, and 3% for small businesses located in historically underutilized business zones and service-disabled veteran-owned small businesses. For federal agencies to meet these goals, they need to have the right tools in place. The National Defense Authorization Act for Fiscal 13 contained provisions to provide acquisition personnel resources to help small businesses receive approximately $80 billion annually in contracts. SBA has made significant strides implementing many of the provisions included in NDAA 13. We revised our regulations to eliminate the caps on the dollar threshold of contracts that could be awarded to women-owned small business under the Women-Owned Small Business Contracting Program. The cap removal will help close the gap between WOSB accomplishments and the 5% goal. SBA understood the importance of eliminating this barrier and acted quickly to issue an interim final rule to implement the change, which was incorporated into the federal acquisition regulations last June. We continue to review and update as necessary all size standards. SBA has completed its review of all revenue-based size standards and issued an inflation adjustment last month. As a result, thousands of additional small businesses will be able to qualify for federal contracting opportunities. As we continue our review of size standards, we have integrated the relevant changes from NDAA 13 into our process. Additionally, SBA raised surety bond guarantees limits from $2 million to $6.5 million and allows for bonds up to $10 million if the contracting officer certifies it is necessary for award of the contract. This provides small construction companies with the ability to bid on and obtain larger construction contracts. We are also aware of the importance of senior-level accountability to small business contracting goals. We have worked with procuring agencies to ensure that senior executives receive training on small business contracting and that meeting small business contracting goals are actually a part of their performance evaluations. SBA's Procurement Center representatives have also incorporated new small business contracting provisions into the trainings they regularly provide to contracting officers. We continually leverage our work with the Small Business Procurement Advisory Council to share best practices and review the performance of the OSDBU offices at every agency. At the beginning of June, SBA submitted a draft rule to the Office of Management and Budget's Office of Information and Regulatory Affairs, authorized by NDAA 13, which will allow the small business prime contractors to utilize similarly situated small business subcontractors to perform the required percentage of work on contracts. This will allow small businesses to work together to win contracts that are larger and have more complex requirements, and that have historically not been suited for small business participation. In the near future, SBA will publish a rule to implement a new government-wide mentor-protege program. The mentor-protege program will be for all small business concerns, including socioeconomic subcategories. This program will be consistent with SBA's mentor-protege program for participant in the agency's 8A business development program. Last month, we published a proposed rule on advisory size determinations, which establishes the criteria that small business status advisory opinions must meet in order to be deemed adequate and specifies the review process for such opinions. This rule further amends SBA's regulations to update the circumstances under which the agency may initiate a final or a formal size determination. SBA continues to review the small business contract goaling guidelines and has now included leasing to the extent reported, which was a category of spend previously excluded. SBA is reviewing the SBA's Office of Advocacy's recently published recommendations for improving the goaling process, and we are working with OMB's Office of Federal Procurement Policy, General Service Administration, and other agencies to determine any future improvements to this process. At SBA and across the administration, we are committed to ensuring that more small businesses have access to contracting opportunities to grow their businesses and create jobs in our communities. As Administrator Contreras-Sweet highlighted in her priorities speech last month, the SBA will be a market maker for small companies by opening new business channels within the federal government. Thank you for your continued leadership and support, and I look forward to your questions.
Thank you. I appreciate the laundry list of what you've completed, but we're really here to talk about what isn't done. Of the 54 regulations and the 40, I think, roughly, that have been not completed. So that's the gist of the argument here today. I appreciate the work you've done. Also, the notion that that was put out there somehow that you're underfunded for this work, yet some $39 million has been spent on things like a website, $6 million for a website, a new website, and so I guess what I'm saying is that this is the law. There is a requirement. There was a schedule, a time, and you also heard Ms. Stiles say clearly that there were things that are very important and they're not done. So I guess I would just like to know how you feel about the comments you heard and give you an opportunity to talk freely about your opinion of what you heard.
Sure. First of all, thank you for the question. I appreciate having been here to hear those comments. It's very helpful in my role to understand the impact that we're having in the community. And I really appreciate when I'm out in the field and actually meet with small businesses to receive those comments. What I will say is, with respect to the NDAA 13, where we found opportunity to move quickly, especially under the woman-owned small business cap removal, where we think that will gain significant traction and help us to achieve our goals, we moved rather quickly and did an interim final rule. And actually worked with the administration to adjust the federal acquisition regulations to take effect immediately, or at least by June of last year. Where we have to work with our sister agencies, where we have equities in our sister agencies, where rules can impact those agencies, I think it's very critical for us to work very closely with those agencies to make sure we get the rulemaking process correct the first time. These are rules that do have significant impact and will have significant positive impact. But we want to make sure we get them correct the first time around. And we also want to make sure that they go through the public comment period, and that the public small businesses, the small businesses that are going to be affected by these rules, have an opportunity to actually comment on them.
So what would you say to someone who said that you're ignoring those you like and addressing those that you don't like? Because that's kind of what it feels like. And I appreciate that you have other agencies to coordinate that with, but 19 months is a long time. Sure. And the fact that you put up an officer's a website today, that there's questions that really need to be answered, and I think that it's important that everybody trust the system.
Sure.
That you administer.
And obviously, I would argue that there's always room for improvement in the rulemaking process. I would argue that the rulemaking process within our agency is such that we want to make sure all the various equities within the agency understand the impact that this is going to have. We work closely with all the other affected offices at the SBA. But at the same time, when there is opportunities to move quickly and go to interim final rule, we have been able to find those opportunities.
Are there rules that you have no intention of following, of the 40 that are left to address?
I would argue that of the rules that were mentioned today, as I mentioned in my testimony, both with respect to the subcontracting requirements, that rule is at OIRA for clearance, interagency clearance, and will be going out for public comment shortly. And we look forward to receiving public comment on that.
Do you have some kind of timeline and when you expect to
Certainly.
finish the rest of it? I mean, it's a long list.
Certainly. I think
There were numerous hearings to come to make those rules.
I think the
come about.
NDAA 13 rule that is currently in OIRA takes quite a load of the laundry list that was presented here today. The mentor-protege rule that is also waiting for our administrator's signature and should go out shortly for interagency clearance, that also takes a significant stab at what we've heard here today.
And you heard
raises
someone
potential.
suggest that mentor policy should be expanded or moved down the food chain, actually, to smaller businesses as opposed to. I'll yield to Ranking Member Meng. Thank you.
Thank you, Associate Administrator Shiraka, for being here today. You mentioned the SBA's Mentor Protege program, where small businesses can receive subcontracting opportunities. This allows mentors to pass subcontracts to small business protege firms. Can you tell us how many of these opportunities small businesses have received through this program?
Currently, the Mentor Protege program that we have is for our 8A Business Development Program. And I don't have the exact numbers, but would be happy to share those with you in the future. What I will say is that the Mentor Protege program is a business development program, right? It shouldn't be viewed as a contracting program, as I'm sure you're aware. The intent of the program is to provide some benefit to the protege, be it technical experience, management experience, financial wherewithal, and that transitionary period helps to grow that protege so that in the future it can go after contracts on its own. So the Mentor Protege program for the 8A program, as we've heard here today, has been very beneficial in providing opportunities for small 8A firms, and the intent is to expand that to all small businesses.
Okay, I yield back.
Ms. Clark, or we have votes in a few minutes, but we do have time.
Thank you, Mr. Chairman. Administrator Shiraka, I have a fairly basic question. The broad lack of compliance regarding the Office of Small and Disadvantaged Business Utilization is staggering. OSDBU is a critically important agency, yet almost all of the mandated reforms are as yet unmet. I don't believe the SBA is maliciously ignoring congressional intent. So could you give us a better understanding as to why, as we sit here today, the guidelines and or regulations have not been issued?
Certainly. Statutorily, we don't have authority over an agency's OSDBU. However, we work very closely with them through the Small Business Procurement Advisory Council. SBPAC meets regularly, and we talk about and present best practices that have been successful in our sister agencies and how those can be implemented at other agencies and how OSDBUs can be more successful in presenting small businesses to the contracting community and representing small businesses in the contracting community and making sure that the agency actually meets its goals. What I will say is that the administration, through the White House Small Business Procurement Group, asked that agencies look at OSDBUs reporting directly to a deputy secretary or higher. And we spent some time, as the agency sort of responsible for monitoring that, spent some time working with each OSDBU and tracking the fact that more and more of them over time have been compliant with that request. And I know that that became effective in NDAA 13. I think that's really critical in making sure that the small business community's voice is heard at the agency. And I think as we see OSDBUs reporting to senior executives at the agency, small business procurement has become a major initiative at those agencies, and we've seen a lot of traction when it comes to small business procurement.
Well, I want to encourage, as probably part of that working group, that there be some pressure applied here, because their role is just so critical for them to be sort of trailing behind.
Absolutely.
It doesn't accrue to a benefit to our businesses, and so to the extent that you through your relationship, you can urge. And also express to them our concern here at this committee, that would make all the difference in the world.
Thank you.
With that, Mr. Chairman, I yield back.
Ms. Velazquez?
Thank you, Mr. Chairman. Administrator Shiroka, I continue to be frustrated by the lack of progress on the women business procurement. And when you have only 806 contracting actions worth approximately $40 million awarded last year, there's no other way to describe it as a failure than it has been really a failure. I need to ask you, what steps are you taking to ensure that the program is fully utilized?
Thank you, Congresswoman. I think the program itself has been critical in bringing visibility around women-owned small business procurement. As you are,
But the numbers.
Sure, and as you are aware much more than I am, the law was established in the early 2000s, and the administration really took the effort in 2009 to establish the program. What I would say is that our administrator is very keen on making sure that this program is effective. It is unique. There are 83 NAICS codes where contracting officers can set aside a contract for women-owned small business programs. I think with removal of the caps, we are seeing more and more traction where set-asides can actually happen, because with caps of 4 and 6.5 million, you can imagine how many thousands of contracts would have to be set aside to achieve that 5% goal. So I think that was really critical, and it was critical that we moved quickly to take those caps out. What I will say is that we work continuously to train contracting officers, and not only that, we have co-sponsorships with American Express Open and Women Impacting Public Policy to bring education around the program to women-owned small businesses, because when they take ownership, they've really been demanding at agencies to take ownership of it as well.
We'll see next time that
Thank
you
you.
come before this committee.
Thank you.
We heard one of the witnesses on the first panel raise concerns over two regulations within the department that seem to conflict with each other. And without getting into those specific details, I want to ask you, if this committee had actually done its work by reporting bills, filing a committee report, debating these bills on the floor, and going to conference with the Senate and producing a conference report, would that have made it easier for you to reconcile what Congress' intent was on these provisions, as well as helping speeding up the process in getting those regulations done?
Sure. Thank you for the question. With respect to that particular question around suspension and debarment, I'd say that's obviously not necessarily in my lane. It's our Office of General Counsel. What I will say is that any time there is the intent of Congress can be clearly discerned by us, it's very helpful in developing rules and regulations based on that.
But would you agree on my estimation that when you build a congressional record, will make it easier for those who are working on drafting those regulations and issuing those regulations? Because whenever there is, regulations is a very complex actions, and you need sometimes to go and look at what was the intent of Congress. When you lack a committee report and when you lack debate on the House floor, then that record doesn't exist. And what I'm asking you, do you think it will make your work much easier?
So, again, thank you for the question. My involvement in the rulemaking process, being that I'm not the lawyer at the agency and I don't actually draft the rules, is making sure that they're timely as to the extent possible, and making sure that they reflect congressional intent and making sure that they reflect the statute. What I would say is that, in my view, anytime that can be discerned more clearly, it's helpful to the process.
Thank you.
Thank you, Ranking Member Velazquez. There are committee reports to look at for all of the hearings that happened, and as a practical matter, these are the law, so it's not, we're not here to interpret them, we're here to respond to them and put these in place. So I want to thank you here today for being here, sir. I know you've been here many times and you're always gracious, and I appreciate that. I think that it's important that we all owe small businesses as quick and efficient and clear a response as we possibly can, and try to help weave them through the bureaucracy. To that end, I don't know what this committee can do, but I think if you're experiencing trouble with agencies and getting them to respond, I'm sure that Chairman Graves and Ranking Member Velazquez, if I speak for her, would be happy to help you navigate that and perhaps make people more responsive. I ask unanimous consent that members have 5 legislative days to submit statements and supporting materials for the record. Without objection, so ordered. This hearing is now over, and again, I want to thank everyone for being here.
Thank you.